for me, because all we've heard for 103 days is about a most remarkable man, and nobody has come forward, and they scoured his every shred of life, and nobody but you and another witness apparently who's alleging no sexual harassment has come forward. And so maybe it seems to me you didn't really intend to kill him, but you might have. And that's pretty heavy. I don't care if you're a man or a woman, to know that 43 years or 35 years of your life or 60 years of your life where no one has corroborated what is a devastating charge, kind of a singular torpedo blow below the waterline, and he sinks. Well, 103 days of accumulated things never penetrated the armor. So I guess I would just say it is a very troubling thing to me. It really is. And, you know, leave out who leaked what to who or what media person let it out. That's all will be hashed. But let me tell you, if what you say this man said to you occurred, why in God's name, when he left his position of power or status or authority over you, and you left it in 1983, why in God's name would you ever speak to a man like that the rest of your life?
That's a very good question. And I'm sure that I can't not answer that to your satisfaction. That is one of the things that I have tried to do today. I have suggested that I was afraid of retaliation. I was afraid of damage to my professional life. And I believe that you have to understand that this response, and that's one of the things that I have come to understand about harassment, that this response, this kind of response, is not atypical. And I can't explain. It takes an expert in psychology to explain how that can happen. But it can happen, because it happened to me.
Well, it just seems that so incredible to me that you would not only have visited with him twice after that period and after he was no longer able to manipulate you or to destroy you, that you then not only visited with him but took him to the airport and then 11 times contacted him. That part of it appalls me. I would think that these things, what you describe, are so repugnant, so ugly, so obscene, that you would never have talked to him again, and that is a most contradictory and puzzling thing for me.
Thank you, Senator. Senator Simon.
Thank you, Mr. Chairman. First, Professor Hill, let me say to your parents, you have a daughter you ought to be very, very proud of. I'm sure you're proud of your whole family. I want to underscore what has been said by my colleagues, that you have shown great courage and you have handled yourself with dignity. And you have lifted the level of consideration of this whole question of sexual harassment as no one has done before in the history of our country. And no matter what happens on the nomination, I think you have performed a real public service. On the question of sexual harassment, you and I know, and the members of this committee know, that physical contact is not necessary for sexual harassment. But I have had two people tell me over the phone that there couldn't have been sexual harassment because there was no physical contact. If I can use another analogy that I think people would understand, if you were to receive the kind of language over the telephone that you received in an office, would you consider that an obscene phone call?
Yes.
And I think everyone understands obscene phone calls. Let me just, two totally disconnected questions beyond this. You say in your statement, in February 1983, I was hospitalized for 5 days on an emergency basis for an acute stomach pain which I attributed to stress on the job. One of the things we have to do in this committee, and my colleagues in the Senate have to do, is to make an evaluation who is telling the truth. This is something objective that happened out there. But when you say, which I attributed to stress on the job, did your physician also suggest this as a possibility?
The physician suggested that it could be stress related. They could not identify the nature of the illness. They couldn't give a medical diagnosis. So the physician did suggest that it might be stress related.
And then finally, and this has been partially touched upon, but there are those who say the timing of this is all some kind of a plot, is the term I hear over and over. I recall calling you the day before our committee voted when we talked about the possibility of distributing this to your statement to members of the Senate. And I said, you can't do that and keep it confidential and keep your name confidential. I sensed that you were really agonizing on this whole thing, and I think I sensed correctly for obvious reasons. But this thing gradually built from the time you first contacted or had contact with the members of the Senate staff and Senate committee. Was there at any point anyone who suggested if you hold this out till the last minute, you could have a great impact on this process?
No one ever suggested that, not at all.
And then finally, let me just make a suggestion. You're always giving assignments to students at the University of Oklahoma Law School. If I could give you and your fellow faculty members at the University of Oklahoma Law School and your law students an assignment. We face a very difficult problem, and it is not just with the Thomas nomination. How do we deal with a charge that someone makes that is a substantial charge, but that person says, I don't want my name used publicly, or even I don't want the charge made publicly? We should not simply ignore it. On the other hand, how are you fair to a nominee? This is a struggle that this committee has gone through and the Senate is going through. I would be interested in you and your colleagues taking a look at that, sending a letter to members of this committee. But again, I thank you. I think you have performed a great public service. Thank you, Mr. Chairman.
Senator Grassley.
Professor Hill, let me at the outset be very candid and tell you that even though the issues that have been discussed here this afternoon and this morning are very, very important, if I had to ask some of these questions that were asked of you today, I would not be able to do that. That's just not my nature. But I have one question and a couple comments, and this is in regard to your testifying that you were approached by Senate staff members about disclosing these allegations. My question is whether or not any other individuals or any other organizations other than those who you've publicly stated today or otherwise, or Senator Specter has stated, whether any other individuals or organizations have approached you about disclosing these matters to the Judiciary Committee any time since Judge Thomas was nominated by the President on July the 1st?
No, no other organizations or individuals have approached me to disclose this to anyone. Do you mean prior to the contact from or even after that? No one has said anything?
Any time during July, August, or September, other than those names that have already been discussed here today?
No, no one has urged me to do that or even approached me about it.
Okay. Now, a couple points that I would like to make, and I suppose I'm making these more for my colleagues than I am for anybody else, but one of the hardest parts of this discussion for me is the fact that if any of our Senate employees had a complaint of sex harassment, that individual would not have the same remedy that you had available to you, Professor Hill, when you were an employee of government, particularly EEOC, although I know you chose not to make that and pursue that remedy. Because like so many laws that we pass, the United States Senate has exempted itself, or we have exempted ourselves as employers, from the coverage of Title VII, including the EEOC rules governing sex harassment. That is a situation that I hope that the Senate will soon change so that our employees will be treated fairly, just like any other employees. On another point, there's been much said, and of course each of us on this committee have had to deal with this as the press has asked us how come we didn't consider all these things prior to voting this out of committee. So that deals with the process of the Judiciary Committee. People are asking how we could have let your statements slip past us. How could we have had the committee vote without airing this matter? Those are valid questions, and let me say that I'm going to work towards ensuring that this never happens again. I realize, of course, that our committee gets hundreds, maybe even thousands of allegations in a nomination like this one, and we rely upon our chairman and ranking member to determine which ones need investigation and which ones might be coming from cranks and crackpots. They determined this one needed investigation, and they called in the FBI, but somewhere along the process, something broke down. So I would like to work with the chairman and ranking member and other colleagues to establish a new ground rule. Whenever the FBI is dispatched, every committee member should be notified about the nature of the allegation. And when the FBI has completed its work, every committee member should be notified and have access to that report. And a determination by the committee should be made as to how we need to proceed with any allegations. A rule like this should ensure, once and for all, that even an 11th hour charge like yours has been fully considered. I yield the floor. Or you can comment if you want to.
I would like to, for a moment, revisit your first question. I'm keenly aware that I want to be certain of my answer. The first question, it was whether or not anyone had contacted me to urge me to come forward with this. No, no one did that. Ms. Hirschner did contact me and reminded me of the situation, and we discussed the fact that we had talked about this earlier years, but she did not urge me to come forward at all.
Thank you, Mr. Chairman.
Thank you very much. Of course, the state of the law actually is that women, even in these kinds of situations, don't have adequate remedies. All they have is an injunction. They're not permitted to get any damages, which is one of the matters that's being addressed in the Civil Rights Bill.
Thank you,
Senator from Wisconsin.
Professor Hill, as you have said, this has been a difficult time for you. You wanted to make the committee aware of your experiences with Clarence Thomas, but you also wanted to preserve your privacy. And that is understandable, and we deeply regret that it has not worked out this way. But while the process may have failed you, Professor Hill, you certainly have not failed the process. For without making at this time any judgments about the ultimate truth of your claims, we can make a certain judgment about the value of the public discussions that your claims have created. All of us have learned a great deal about and become more sensitive to the problem of sexual harassment and inappropriate behavior. The issue is complex and our understanding may never be complete, but your perception of your relationship with Judge Thomas is clear in your own mind, and your courage in coming forward and the composure you have demonstrated since this issue became public all speak to your character. I'm sure this has been very painful for you, as it has been for all of us, but I believe that the pain will vastly improve the way that men and women respond to this problem throughout our country. Thank you very much.
Thank you, Mr. Chairman. Professor Hill, you were kind enough to take my call earlier this week and were very forthcoming, and I appreciated that and the information you provided. I had a few additional questions that I thought might be helpful that I would bring up. My impression was that the calls from the staff that had originally prompted you to begin thinking about making a statement included not only questions about sexual harassment, but had actually implied to you that there were rumors circulating about sexual harassment at the EEOC, and even a suggestion that there might be rumors to sexual harassment related to you. Now, could you share your view of what those rumors were or what they had suggested to you in those calls?
Well, when I received the calls, I assumed that someone had known about the incidents as they were occurring who I did not know, who might have contacted the offices that called me. So when the statements were made and the questions were asked, I assumed that it was someone who knew that these things had happened and that they had come forward to the committee or to the individuals who were calling, and that they were following up on that.
I guess what had occurred to me when I heard that description from you was the, at least inference in my mind, that the fact that there were stories, or there could be stories circulating relating to sexual harassment and perhaps the sexual harassment towards you, that was one of the factors that encouraged you to come forward.
That was definitely one of the factors. I didn't want the committee to rely on rumors. I didn't want the rumors to perhaps circulate through the press without at least considering the possibilities or exploring the possibilities through the committee process of coming forward. So yes, that call, those calls and those raising the issue with me very much encouraged me to further explore the process to determine how and if I could come forward.
You mentioned that you talked to several staffers and then eventually made a decision to come forward, and you chatted with a committee and had a variety of conversations there. Were there others that you talked to after you talked to those two staffers and before you decided to speak to the committee?
I talked with personal friends. I talked with with individuals who knew more about Title VII law than I did.
But I take it none of these conversations included people who were actively opposing the nomination?
No.
When on the employment question, I thought I would go back to it. I must tell you, my own impression is that I think if you have a job, you're reluctant to leave it without some other offers. But I thought it might be helpful to put a cap on that. At the point that Judge Thomas was leaving the Department of Education and had invited you to accompany him or go with him in terms of a job assignment over to the EEOC. Did you contact anyone in the private sector for a job? You've already talked about not exploring alternatives within the education department, but did you contact anyone about a job at that point?
I did not contact anyone in the private sector. I had left the private sector 9 months earlier, had decided that I did not want to return at that point to the private sector.
At the point that the harassment, or at least the harassment that took place, that was alleged to take place at the department, education department, did you begin to explore job opportunities at that point? As I understand, that was a point before, sometime before the decision to leave.
No, I did not explore. I may have read government printouts, but I did not actively look for another job.
With regard to the judge himself, you clearly, in working with him as you had, were familiar with a portion of his philosophy. Do you find you were in agreement with his philosophy on most issues? Opposed? What can you share with us on that?
Well, I'm not really sure what his philosophy on many issues is, and so I can't say that I'm in agreement or disagreement. I can say that during the times that we worked, there were matters that we agreed on, worked together. There were matters that we agreed on and some that we did not agree on. And we had discussions about those matters. But I'm not really certain what his philosophies are at this point.
Would that be the case with regard to, say, abortion or Roe v. Wade?
That I'm not sure of his philosophies?
Well, sure of his philosophy, or do you perceive a significant difference between the two of you in that area?
Yes.
Can you tell us what that might be? I don't mean to pressure you here. If you would prefer not to, well, please don't. But if there's something you could share with us in that area, I think the committee would like to hear it.
Senator, I don't, on behalf of, from Judge Thomas's position, this was supposed to relate to harassment, not investigation of Judge Thomas's views on abortion.
Mr. Chairman, you're perfectly correct. I merely, if there was something that wished to be offered there, I thought it would be helpful. I see the red light is on, so I will.
Now, both two of our primary questioners also want to take an additional 5 minutes, or one such portion of those. Senator Leahy.
Make it very brief, because everybody is tired and want to go on. Professor Hill, you were asked questions by Senator Simpson regarding this afternoon's FBI investigation, which I believe you were shown, and a question of whether there may be some inconsistency. That's a matter that, I mean, everybody's going to have to determine whether they feel there is or is not. I make those statements of that, but basically on the thrust that you were less specific about these incidents, the language and the description of these incidents, when you talked with the two agents than you were in your statement here today. Let me just 3 or 4 very quick questions. I think you could probably even answer yes or no. The statement you made here today was made under oath. Is that correct?
Yes.
And that statement was more specific than the conversation that you had with the FBI agents. Is that correct?
Yes, I agree.
And when specific questions were asked by different senators about that, you went to even more specific details of the language that you say that Judge Thomas used. Is that correct?
Yes.
And if there had been even more questions going specifically conversation by conversation, it would be safe to say that you would have even more specific language.
I would have attempted to.
It would be safe to say also that you found it uncomfortable repeating even the language that we elicited from you in the questions.
Yes.
Thank you. I have no further questions.
Thank you. Senator Specter.
Thank Chairman. Just a word or two. When you say, Professor Hill, that by hindsight, as I wrote this down, it's difficult for me to understand. And in looking at the entire record, it is difficult for me to understand. You have substantially enlarged the testimony which I had expected based on the FBI report and your statement as to what you allege Judge Thomas had done. The critical move from the Department of Education to EEOC is not understandable to me, where you make the statements about his offensive conduct for an experienced lawyer not to inquire about standing, or even an inexperienced lawyer not to inquire about standing to stay at the Department of Education, or not to make an inquiry of the people in charge. The toll calls you characterized as garbage, which you admitted to in your interview with the newspaper, although you denied other aspects. You now concede to be true that you did make those calls. It is one thing for you to say that you felt constrained to maintain some sort of an association with Judge Thomas in the face of this kind of conduct which you have represented, but why make the calls which you agreed to? The "how are you doing?" or "I'm in town," or "tell his secretary you're in town." Why drive the man to the airport? Why maintain that kind of a cordial association in the face of this kind of conduct? We have an office, Equal Opportunities, EEOC, to enforce the laws on sexual harassment. And we have here representations that the nation's chief law enforcement officer has sexually harassed his attorney advisor. And that attorney advisor is dedicated to enforcement of the law against sexual harassment, and tells us that she moved from the Department of Education to EEOC because she wanted to protect the women of America. And conceding that this is an enormous educational experience, the question is why, with an experienced lawyer in that position, being concerned about women's rights, do you leave a man, Clarence Thomas, as chairman of the EEOC for years, when, according to your testimony, he has been guilty of sexual harassment himself? Now, I do see explanations at every turn, and I have wondered about the quality of those explanations, candidly. But there is no description for this entire proceeding other than a tragedy. I do not know how Judge Thomas defends himself beyond stepping forward and saying that he's shocked, surprised, hurt, and saddened. And the shortest statute of limitations I've ever heard of is 180 days. Until I got involved in this proceeding, I didn't know there was such a short statute of limitations. Contract cases are 6 years, tort cases are 2 years, criminal cases are 5 years, but the federal law has put that into effect because it is so difficult to defend and to go back and to recollect all that has happened. And I appreciate the stark nature of the statements which have been made. But I also see that in your own statement, which you prepared at your leisure, but aside the FBI statement, you were with two people, but no mention about the Coke bottle, no mention about sexual prowess, no mention about other major issues which are in your statement. So that I conclude, looking at this very complex day, on our obligation to try to find out what happened between a man and the woman a long time ago when nobody else was there, that I would agree with you, Professor Hill. It's very difficult for me to understand.
Thank you, Senator. Senator from North Carolina. South Carolina, I beg your pardon.
Well, don't forget it.
I realize there's certain things I should never say to the senator from South Carolina, and one of them is that he's from North Carolina.
Mr. Chairman, I just have one brief question. Professor Hill, I understand you told the FBI that you have had concerns about the political philosophy of Judge Thomas and that he may no longer be open-minded. Is that accurate?
I told them that I did not quite understand, but as they had been represented, yes, that I did have some concerns.
I have the FBI report here. I just wondered if you remember telling them that.
I remember a discussion about political philosophy, and I remember specifically saying that I'm not quite sure that we understand his political philosophies, but based on what I understand, yes, there is some discomfort.
That's all.
Thank you. Now, let me just say, Professor Hill, we have heard, in a sense, half of this story today, all of your story, and we have not heard all of Judge Thomas's story. But I, for one, can assure you that, assuming for the moment what you have said is true, there is nothing hard to understand. Having spent as many years as I have dealing with the issue of victimization of women, it is every single psychiatrist and psychologist who considers themselves expert in the field will point out that the nature of response is not at all atypical, assuming it to be true. And please do not be offended by my saying assuming it to be true. I view myself again here as a finder of fact, and we have yet to hear the whole story from Judge Thomas. This is a tragedy. People keep mentioning that. And my good friend from Iowa hopes that this will never happen again in the sense the way the committee handled it. I must be brutally frank with my colleagues and with everyone else involved. I do apologize to the women of America if they got the wrong impression about how seriously I take the issue of sexual harassment. But I make no apologies for attempting to follow every one of your wishes, because every one that I've spoken to, again, in the years that I've dealt with this subject, indicate that the most unfair thing to do to a woman in your position is what was done to you. Force you to do something that you did not intend to do. And so I must tell you, I must tell everyone else, I take sexual harassment seriously, but I take your claim and took your claim that you have reasserted here today a half a dozen times that you did not want this to go public as seriously as I possibly could. And for those who suggest that I should not have, or that there was some way to do it differently and still honor your commitment, I know of no such way to guarantee that your anonymity, to guarantee that you would not have to be in this place at this day. I must tell you, every instinct in me in the world wanted to say to the whole Senate and to the whole world that we should have a hearing on this. But again, we tend to look at large issues and forget individuals. You were the individual in the middle of this. And I will say again to anyone who will listen, as long as I am chairman of this committee, if a person comes to me in a similar circumstance and says repeatedly and in different ways that I have no right, I have no authority to tell their story, to leak their story, to demand that their story be put in a context different than they wish, I will honor that commitment. And I appreciate the fact, and to be very, very blunt about it, I can't tell you how thankful I am, purely from a personal standpoint, and I shouldn't say this, but I'm going to say it anyway, that you were so straightforward and honest about the way in which this committee handled your request, and so straightforward and honest about, notwithstanding the occasional confusion, how you did not decide to do what is being done here, were it not for the fact that it was leaked to a press person, you would not be here today. It seems to me, ultimately, in this great, giant machine we call this nation and this government, that I don't know how we can call ourselves civil libertarians. I don't know how we can call ourselves people interested in the individual if in the name of a larger cause, to justify the ends, we make a judgment for an individual that that individual chooses and has a right not to make. So I must tell you, I admire you. I admire the way you handle this matter once you were confronted with it. As I said to you very bluntly over the telephone, all of us up here choose to be in this business. We choose to be under these lights. We choose to be under the scrutiny of those ladies and gentlemen sitting behind you. We choose to go before the American public and say, judge me. But we have no right to make you choose to do that. And once you chose to do that because you had no choice, you handle it with such grace and such a lean that I can't quite understand how you were able to pull it off, in the sense of walking before all those press people in a press conference and handling the way you did. I don't know 3 candidates in my whole life who could do that, and they've had 27 handlers telling them how to do it. So I don't want to kid anybody. If you came to me again in the same circumstance, then Senator Biden, keep this tight. Do not make it go public. I would do the same thing again. And I thank you for your honesty in laying out just what you did, because you could have very easily said, oh no, I would have come forward no matter what. I was getting ready to do that. And quite frankly, make me look like an idiot and make the whole process look like an idiot. So I thank you very, very much. But most of all, having nothing to do with the process, we can all talk about the process. It's a cumbersome one. But ultimately, it seems to me the purpose of the process is to protect the rights of individuals. I thank you for being willing to be here. I thank you for your testimony. We will now recess. Judge Thomas has indicated, I'll yield just a moment. Judge Thomas has indicated he wants very much to come back on this evening. So we will reconvene this hearing at 9 o'clock and to hear from Judge Thomas. Before we do, I yield to my friend from Alabama who wants to submit to the record some, well, I'll let him say what he wants.
Mr. Chairman, I want to submit certain newspaper articles that have appeared. We will supply to it, but make them for the record. This is from the Washington Post, October the 11th, 1991. The headline is Thomas's View on Harassment, said to evolve. From the Baltimore Sun, dated October the 11th, 91, Thomas Hill disputes. From the New York Times on October the 10th, 1991, stark conflict marks accounts given by Thomas and professors. In the Washington Post, same date, conflict emerges over a second witness. From the Washington Post on October the 11th, 1991, Charlotte woman detailed Thomas's conduct. From the New York Times, October the 7th, 1991, law professor accuses Thomas of sexual harassment in 1980s. And from the U.S. News and World Report, September the 16th, 1991, the article titled The Crowning Thomas Affair.
Without objection to be placed in the record. Again, I thank your family. Yes.
I would just like to take this opportunity to thank the committee for its time, its questions, and its effort that is put into this investigation on my behalf. Thank you.
Thank you. Adjourned till 9 o'clock.
About once a decade, the McCarthy hearings in the 50s, the Vietnam War hearings in the 1960s, the Watergate hearings in the 1970s, Iran-Contra in the 1980s, and now in the 1990s. You see this kind of drama under the dome of the People's House, the United States Capitol in Washington. Oklahoma law professor Anita Hill accused Supreme Court nominee Clarence Thomas of vile sexual harassments. Thomas flatly denied any misconduct. This in sworn, televised, broadcast testimony laced with lurid details and powerful drama. Now, for those CBS stations who choose to carry it, there will be an abbreviated edition of the CBS Evening News immediately following this broadcast. Some of your CBS stations will not be carrying that, but for those who do, a shortened version of the CBS Evening News will immediately follow our sign-off here. This concludes our CBS News live coverage of the Thomas nomination hearings. The hearings will resume, as you heard Senator Biden, the chairman, say a moment ago, at 9 p.m. Eastern Time tonight. Because of a CBS Incorporated contract with Major League Baseball, Game 3 of the American League Baseball Championship playoffs will air as scheduled at 8:30 Eastern Time tonight. Obviously, the continuing hearings can be seen on other stations in your area. CBS News will return with coverage of the Thomas hearings tomorrow morning. For CBS News, Dan Rather with a reminder that on many of your stations, a shortened version of the CBS News Evening News follows. I'll see you along the way.
This is CBS.